What's up, everybody? Welcome into another video here. Major hearings happening today in the Kohberger case, motions to suppress the IGG info, among other things, and we won't be able to watch it in its entirety. And to find out why, we're going to go through yesterday's hearing, listen to the arguments, listen to some of the things the judge had to say about why the defense is requesting certain things and how they are working this case now that maybe he doesn't want to continue in the future. But he also has a pretty balanced approach to how we're going to deal with things going forward. So we're going to learn a ton from this hearing when we hear what the judge has to say, hear what the arguments are for transparency and things being open to the public and how important that is and why we need it. So we're going to go through everything in the hearing, answer your questions. Let's get to it. All right, so this hearing happened yesterday, and the lawyers for the state were there, the lawyers for the defense were there, the lawyers for the media are there. We've heard from these lawyers before, especially the lawyer that's going to be doing most of the arguing on behalf of the media. And the major question is, what, if anything, call back to Johnny Depp, will be public about these motions to suppress? And we're going to listen to a lot of the comments by all the lawyers, and I'm going to give my thoughts as we go. But generally speaking, we've got to figure out, and the judge has to figure out, where is the line between transparency and fairness and what should be sealed and should not be sealed? Why would things be sealed? And why this is a particularly difficult decision now for the judge that's very different from the beginning of this case. And you can think about what has changed. And you can throw it in the chat if you've thought about what has changed from the very beginning of the case where things were getting sealed left and right and now. Let's get to it.
Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion.
People are saying call back to Karen Reed. My bad. They all run together at this point. But the interested parties that the judge is talking about, meaning not the defendant, not the prosecution, but those are the media outlets. Those are the interested parties that are fighting for this hearing to be public and open in its entirety.
Of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olson or Mr. Peterson's addressing the court today, but whomever is may address the court.
Thank you, Your Honor. Will be Ms. Olson on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, and in Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion, there is no reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated...
So basically she's saying this isn't a situation where normally you would close the cameras out. And just because it's a motion to suppress, there's been case law that said cameras are allowed in motions to suppress. And why is that so important? Well, it's possible the public will hear about evidence that obviously doesn't come in at trial if it is suppressed. That's the point of a motion to suppress, to keep evidence out so it doesn't come into trial. And if anybody hears that publicly, which they are usually open to the public, they're going to know something about evidence that doesn't come into trial. But that's part of this public process to see. A lot of motions to suppress are based on, police misconduct or a violation of somebody's constitutional rights. Right? It was an unreasonable search and seizure. You was an unlawful stop and you search the car, whatever it may be. Sometimes you find very legitimate evidence, but people's rights were violated and the public has a right to know who's doing that. Are these law enforcement officers being reprimanded? Are they being fired? Are they still out on the streets violating people's rights left and right? Are they being reprimanded? Are they going back for more schooling? That is important for the public to know. What is law enforcement doing in my community? Should I be worried? If it's the same cop that did it to this person, I want to know if they're going to do it to me as well. We need to protect the community. That's why a lot of this stuff is public and why it's so important.
Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And
So she's hinting at the fact that the public trial is in fairness to the accused, to the defendant. That's why it's very important. Is he being dealt with fairly? And we're going to start keeping track of some of these arguments and then discuss what's different now than the beginning of the case.
in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, the court must afford those excluded from the proceeding reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writing, insufficient so that a party excluded can challenge them.
So what she's saying there is the judge needs to make any order. If he is going to close the proceedings, he needs to make an order in writing and give his reasons so that if they're wrong, these interested parties can appeal it up to the higher court, which has already happened in this case with the gag orders. So it's not a threat. It's more of, judge, you've got to let me do my job. You can't just close the proceedings. You've got to give us the reasons why. And if those reasons why are not good enough or not appropriate, the higher court can open this up for us. And we can have some other remedy and somebody else look at this. If you just say no, and we don't know the reasons why, it doesn't give us that opportunity to fight it further. This is not Kohberger's lawyer. This is the lawyer for the media conglomerates, the interested parties, as they call them here.
Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed.
So she's given the reasons why you would close it. Public interest. If you don't close it, the public interest will be harmed.
And that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 9.
And that there's no other way you can do it but closing the courtroom. Now, what's going to be interesting is, to give you just a little bit of a jump ahead, the court's not closing it in its entirety. He's only closing it with the parts to deal with people's names and IGG, but a big chunk of it. And the defense is not okay with that. And we're going to hear the defense's arguments. But the judge is kind of working with prong 3 there and trying to find a balance that he's going to show some of it, but not all of it. Is that good enough? And according to the interested parties and according to the defense at this point, the answer is no. They're continuing to fight for the entire hearing to be open, which it's, starting a little bit later this morning, but most of it, or the big chunks of it, we're not going to see.
920 F2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interested parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. Second at 1467 and Brooklear 685 F. Second at 1167.
So the burden is on the party seeking closure, which is the state, kind of in conjunction with the judge, and they have to say why. And if it's not good enough, they have the right to appeal it, meaning the media conglomerate, the defendant, et cetera, et cetera.
As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court.
So what is the state's reason for wanting closure? They're worried that the jury pool will get information that will poison them and not make them available to be a jury. And why is that important for the state? In order for the state to also get a fair trial, they've got to be able to pull a jury. If they can't pull a jury, in this case, never goes to trial, there's no justice for the victims, no justice in the community, and they don't get their right to a fair trial. So it's a legitimate concern for the state.
But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that, some evidence that this discussion that would occur in the hearing would taint a jury pool or provide information that would be difficult to seat a jury. I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access.
So number one, my cat's name is Karen, said BK and Taylor want to close. Is that what I'm hearing? No, she said the defense is objecting to this. The defense does not want it closed. And therein lies the big difference from the beginning of this case, where everybody was agreeing, closed hearings, seal these documents. That is no more. And that's what makes this so difficult for the judge. And he's got to be careful with what he's doing and making sure he has the proper findings on the record. Pebbles. So Peter, if the families can't make it to court, this bars them. So I don't know that to be true. There have been scenarios where victims are allowed to get a private Zoom link or show up in person if they want to, that the court's not going to necessarily close it off to them. I don't know if they have set that up in this case, but in cases where I've seen this happen before, the victims are allowed to actually sit in and listen. I don't know if that's going to happen here. Additionally, she makes a good point in saying, basically, if that was the case that, some juror could hear something if this is open to the public, then we would close every motion to suppress. We don't do that. Therefore, we shouldn't close this one.
It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure.
So the state said, Judge, he agreed to the gag order. So now he can't change his mind, and that's just not correct. Number one, she's going to explain some reasons why the gag order doesn't even affect this, which I think are pretty good arguments. But number two, that absolutely does not mean what it is. Just because you agree to a gag order doesn't mean that you agree to every single hearing in the future being closed. No way. That's a totally wrong argument by the state, in my opinion.
Certain if that was the argument that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as the case moves forward.
I agree with her. I think I thought she was really good before when she made a lot of the arguments, whether you agree with them or disagree with them or love the media, hate the media, whatever it may be. I think she's right. I think the non-dissemination order and a closing of a hearing or sealing of documents are two different things, which is why you have to take an additional step to seal these documents. The lawyers have to file. This needs to be filed under seal. Here's the reasons. The judge needs to grant that motion, and then it's under seal. If the non-dissemination order just sealed everything and closed everything, we wouldn't be having these discussions. These are two totally different things. The non-dissemination order keeps lawyers and their agents from going out and being like, Kohberger's guilty. We know it. We have this evidence, that evidence, the other. He's cooked. It doesn't matter what he does. And the defense saying they're doing X, Y, and Z. This is so unfair. This is so inappropriate out in the media. That's what the non-dissemination order is trying to stop. Not all of us, we, the public, having an open access to the court saying, Judge, here's the motion we're going to file. Can we have this hearing? Okay, here's the hearing date. Here's what our expert has to say, Judge. We think we need to move it from this jurisdiction to that jurisdiction. That's not covered under the non-dissemination order. Two different things. And I think she does a good job of separating them. And the non-dissemination order should not affect the judge's decision about this hearing. He can still close the hearing. It shouldn't be because of the non-dissemination order. Kohberger can still object to this being closed. he shouldn't be barred from that objection because he agreed to the original non-dissemination order.
Your Honor, I would submit also that there is tremendous public interest and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission.
I'm going to back it up real quick because she makes a good point. One of the reasons this needs to be open to the public is people need to see, did the state do this investigation appropriately or did they violate somebody's rights?
Time that it's being considered, the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal.
So she talks about how big of a hearing this is. If the government violated his rights and are violating other people's rights, we should want to know that, number one. And if they do, and the court suppresses this IGG information, what is the fruit of that poisonous tree? Can they convict him? Do they even have enough for probable cause? Is the court going to dismiss the case? Is the state going to drop the case if this stuff gets suppressed? And if it's all closed and the public has no idea, I mean, Brian Kohberger's life is also already pretty much over. I hate to say it, but being accused of something like this and being in prison or jail for this many years, waiting for trial, having all these people plaster your face and talk about how you did this, they know you did this. And if you get off on a technicality that nobody gets to see this hearing and everybody sees that, oh, the case got dismissed, what the heck's going on? I mean, he's still pretty much in trouble there for the rest of his life. But having it open and having the people hear exactly what went on, that is of major public interest. This could be literally the biggest part of the case.
The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing—
Do you think that's of public interest? Law enforcement officers making reckless or false statements in affidavits to the court? That sounds important to me. And I'll also say with all this IGG information, right? It's new-ish, it's different. There are different ways to argue against it, argue for it. We're all learning a lot about it. This is going to be something that comes up in other cases. There are a lot of attorneys looking at this. There are a lot of attorneys following things like this, not just because it's a high-profile case, but when anything new in the law starts happening around the country, we lawyers have different groups and different email chains and text chains where we talk about what's up and coming and cutting edge and what's going on and how we're going to argue it, how it's going to affect our cases, how it's going to affect how we do our job. And what's great about that is just because it goes one way in one case, maybe a lawyer didn't think of an argument here in Idaho that somebody will in Florida or New York or California or Texas or whatever it may be. But if people's rights are being violated, if law enforcement or the government, state attorneys, FBI, whatever it may be, are doing something that steps on people's rights, you should want lawyers interested in fighting for and protecting your rights, looking, listening, paying attention, and doing their best to make sure that your rights are being protected. And if they are, and they did everything right, great. That's great. But if they're not, we've got to put a stop to it. And if all of it is public and we get to see each time the way law enforcement does it, that is the best way to make sure it is being done right. We don't need to know anybody's name. We don't need to know any identifying characteristics, but discussing how law enforcement went through the process, what they used to get to Brian Kohberger, what statements they put in this affidavit. Were they true? Were they correct? Were they honest? Were they reckless? Were they false? We need to know that. Yeah, people are asking what IgG is. Investigative genetic genealogy. So it's basically how they went through the DNA stuff to get to Kohberger. And I say that purposely because I don't pretend to be an expert on it. That's why we use experts to explain it to us.
A court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Frank's hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Frank's hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life, liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements.
Couldn't agree more. Couldn't agree more with that.
I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IgG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is—
So remember the three prongs. The third prong is there a less restrictive way than just closing this hearing that we can protect whatever the interest is we're putting forward, which is, information getting out there affecting people involved and the evidence getting out there. She says the evidence getting out there in a motion to suppress, we do that in every case and we don't close motion to suppress in every case, but protecting the identities of the people involved, I think I have other options that are less restrictive than closing the hearing altogether, which is one of the prongs the judge has to consider.
Is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. We would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on?
I think that last little paragraph or comment was like, hey, we see what's going on in other jurisdictions in the country, whether it's the YSL case, whether it's, what people say about the Delphi case, Karen Reed case. We see the public up in arms about how things are going in different jurisdictions, and shining a light on this stuff helps us find injustices like Sandra Birchmore and so many other cases that we've seen go on that were in the dark for so long. And we might never have heard about them if not for the media or for cameras in the courtroom and seeing what's going on. There's no doubt in my mind the YSL case would not have been the same without cameras in the courtroom. It just would have been a case probably that went on for years that nobody seemed to care about. Nobody seemed to find any problems with how any of the government agencies were acting in that case. And I'm sorry, I see people saying, I saw Brianna say, if both parties don't agree, then I think that all hearings should be closed unless both parties agree to have it open. Something like that was her comment. And I just disagree because I think there will be situations where one party, knowing they did something wrong and are going to get publicly aired out for committing fraud or lying, they'll just close that hearing. Judge, we're one of the parties. We want to close it. We don't want the public to know that this law enforcement officer lied or that this state attorney hid evidence. And then the community that they are in, whose lives are affected and freedoms are affected by those law enforcement officers, those prosecutors, those judges, those defense attorneys, they would never know. It would be cloaked in silence. And, you know, I think that, and I am not hating on Brianna at all. She's always in the chat. She's awesome. I appreciate her sharing her input. And we've probably disagreed multiple times on different cases. And I appreciate it because it makes me think. And I think, well, is that a good idea? And as I think through it and I process it, I may fall on a different side. And that's what makes the chat great. That's what makes this discussion great. We two people in America can see it completely differently. And that's why you have judges and lawyers who can see it differently and argue differently and come down on different sides of it. And I think it's an important discussion. And I think everybody in here, everybody wherever you're at, needs to think about it. Is this what I want? What is better for justice? What is better for my freedoms? What is better for our country? That doesn't mean you have to agree with me. That just should just be your analysis, in my opinion. Okay, so now he asks if either of the attorneys on either side have an argument to make.
Ms. Olson's argument that was not previously presented.
I would like to make a record on behalf of the defense.
So I have to mention something. He said, does either of the lawyers have any argument they want to make that has not previously been presented? And Taylor jumps in and says, I would like to make the record of my argument. So the judge, you may not have picked it up, but he said not previously stated. So let's listen to this exchange here, and I'll start to tell you the feeling that I get the judge has for the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard.
So he said, beyond what you did yesterday. So they already had a closed hearing where they made these arguments. He asked anything additional. She says, I'd like to make a record. He said, beyond what you said yesterday. She said, it would be consistent with what I made yesterday. And he's like, I heard what you argued yesterday. It was already on the record. So why can you guys think in the chat, why would Ann Taylor want to make another argument today that she already made yesterday in a closed hearing? What pops in your mind? Why would she want to make that argument?
Yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having.
So he says, do you have anything new to add? And Gray Space says, let her make her record. So, you know, I am all for defense attorneys being able to make their record and fighting to make their record. And I think that they should be able to make their record. Here's the problem. She has made her record. Just because the hearing was closed does not mean it's off the record. It's on the record and it's part of the record. So this argument is already on the record. So she doesn't need to make it again to make it for the record. But everybody very astutely is putting in the chat, open, public. Ann Taylor wants it all out there for the public, publicity. You guys are correct. And the judge starts to let you know how he feels about the fact that Ann Taylor wants to make as much of this public as possible. By the way, I don't disagree with Ann Taylor, but she is trying to circumvent what the judge is deciding in this case, which was to have those arguments closed. So you have to be very careful. It's one thing to say, Judge, you're making a decision. I disagree with it. I think you're trampling on the defendant's rights. This is going to be an appellate issue. I don't think you're letting the defendant have a fair trial because he wants a fair and public trial. But if the judge says no, you can disagree with that all you want. But you better not break the judge's rules, right? You can take it up. You can appeal it. Yeah, good luck. It's always very difficult to win appeals, as we've talked about before. But I think the judge is starting to get a little frustrated with Ann Taylor trying to do this.
The ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
So he made some suggestions in the hearing yesterday about how they can do this in a way, because respect to him, he's trying to handle that third prong and do the least restrictive ways of protecting the public interest in this situation. And so we're going to hear the options he gave to the defense. And I already, said it earlier, the defense is not okay with these options, but these are the options the judge gave the defense to where we can have part of it closed and part of it public.
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed,
Correct.
but that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way.
So frankly, it's smart for the defense not to agree with this, because if they continue to argue it, they protect that record for appeal, or protect that issue for appeal. And they can fight again, and maybe the judge will see it their way. And if they lose, all they do is lose and get what the judge asked them to compromise on anyways, right? So it's kind of like, what do you think about this option? If you say you like it, well, you lose some arguments in the future. If you say you don't like it, well, you're still going to get that. So not a real risk here. And I think the appropriate thing to do as the defense to continue to fight that. If you, of course, have a good faith basis, that's the right thing to do.
So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names, and in particular names of some lay witnesses, in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with
So
respect
that's
to the
information
names,
that I have.
I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
So he's saying when you're making your argument, when we have the public and open hearing, use initials instead of names.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, not beyond what was said yesterday. Thank you.
They already made their arguments yesterday. They're going to stand with those. Now we get to hear from the judge what his decision is and why.
Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting the jury pool that exists here.
But I hate to disagree with the judge, but that was specifically dealing with extrajudicial statements. And it specifically said things like, you can just basically trust what you hear in court or read in the docket, which is public unless it is sealed because it has a reason to be sealed. The non-dissemination order, in my opinion, should not have anything to do with whether or not the public part of this trial should be sealed or not. That's a completely different analysis, just my opinion.
With evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously.
And again, I would disagree and say that each of the different documents that were sealed and hearings that were closed specifically were argued and reasons were determined as to why to close those individual hearings and why to seal those individual documents. That's why we see all these motions to seal and orders to seal each individual time, because the non-dissemination order did not remove the necessity to then take the appropriate steps to seal anything that should otherwise be public.
I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. That's exactly why it's not open. We will.
So he says he feels like this is all about the defense trying to make their case to the public, and that's exactly why it is not open. I don't know if that he mentions the hearing yesterday, so I don't know if the defense actually argued we want to make our case to the public. That wouldn't be great. But the public needing to know what's going on in this case, I think is important. I think it's really important. And what makes all this so difficult is the defense is not agreeing to close certain things or seal certain documents anymore. They were in the beginning, but now that they're not, you have to have the state explaining why and the judge issuing an order every time something gets closed over and above the objection of the defendant who has a right to a fair trial.
Will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to, and I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed, and I've asked the parties to stop that, frankly.
So I love that. And frankly, I think he's going against what he said earlier with the non-dissemination order. He's like, I think we're sealing too many documents. I think you two are stipulating to sealing too many documents, and I've told you to stop because I don't think we need to do that. Which to me indicates he wants what should be public to be public. And whatever he decides, whether I agree with it, whether you agree with it or not, I absolutely believe this judge is trying to do the proper analysis and coming down with what he truly believes is the right thing to do in this case, to respect the public's interest in the case, to make sure we have a fair trial for Brian Kohberger, but to also protect the interests when it's necessary to close a hearing or seal a document. I do think, making that comment, he didn't need to, right? But he makes that comment that I think we're sealing too many documents. I think you guys are stipulating this to too much, and I've asked you to stop. I think that's important. I think that's good that he did that.
And to provide better rationales as to why I should seal what they're asking me to seal.
As opposed to in the past where every motion to seal was the same four things. It'll put investigation techniques into the public that aren't necessary to do so, put victims and witnesses in danger. It's like, but what actually is it? They're just like putting boilerplate language, not actually explaining why something should be sealed because it just gets sealed every single time. The judge is like, no more of that. Explain to me why each individual document on its own needs to be sealed.
That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool.
Before he gets to that, just to answer this again, Leslie, IGG is investigative genetic genealogy, which is like the DNA testing as to how they got and connected this case to Kohberger.
In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talk.
And he's talking about the cop lying or making reckless statements. Like, we don't know specifically what that is. At least I don't. And he's like, making all that public, if it's either like not true or not relevant or doesn't come in a trial, could negatively affect the case. He also kind of holds the motion to change venue against the defense, where he's like, you guys have been worried in the past about poisoning a jury pool and not being able to find jurors. Here's the problem. The defense isn't making that argument. So you shouldn't bring that into your analysis if the defense isn't making that argument and doesn't think that this is something that's going to poison the jury pool. But at the same time, Ann Taylor better not later say, well, hey, because this hearing was open, Judge, we can't find a jury here. We've got to bust this jury panel, find a new jury panel. So you can't have it both ways. So she has to be careful about that. And the judge is kind of mentioning something like that. But also, that's very different than if somebody says, hey, I saw that I think the cop lied, therefore I can't be fair and impartial. Well, they're going to get struck. And that's a risk the defense is taking.
With the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is that for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow.
So while the defense still has a problem with it and the media still has a problem with it because they're always, as they should, push for the full amount of what they're asking for, right? Which is a fully open hearing. What I'm hearing from the judge is he is going to have as much of this hearing open as he possibly can. As much of this hearing open as he possibly can, but when he feels it's necessary, he's going to close it. We'll see how much of that actually ends up being open versus closed today.
Particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change.
And that's the big chunk the defense is mad about. And frankly, I personally think that should be open as well, the challenge to the IGG.
Down the line, my order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Franks hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Franks proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Franks and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the.
So I agree with the words that he's saying, right? We want to do as much of this in open light as possible. Now, what is possible? Minds can differ, right? Reasonable minds can differ.
The petition, I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me.
He says he noticed that the defense has shifted their mindset, which is okay. They're allowed to do it. I mentioned that at the beginning. But he said he's concerned that they want to try it publicly. And earlier in the hearing is when he warned them that that is not what we are going to do. So do not try to try this case publicly. That's the warning to the defense. He is concerned about their tactics of why they want things open now, why they don't want closed hearings. Sorry, I'm screaming. Why they don't want to seal documents. He's worried about that. It's concerning to him. And if something concerns the judge, he is going to try to control it, to fix it, to make sure it does not happen.
I appreciate the defense possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly, as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel, I think it's better that we proceed in this fashion for now.
May I?
So he says, this is how we're going to proceed. Don't try this case in the public.
Is one other issue, Your Honor?
Briefly.
She's like, one more thing, Your Honor. He's like, briefly, he wants to be done.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood judges, the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also
Completely agree.
note that Rule 3.6 does have sort of this rebuttal portion to it that allows if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order.
I don't remember him indicating that either, but he seems a little annoyed with her as well. He's like, I already said I was going to do a written order. She's like, I need the findings because I need to know what to appeal, because I am going to appeal this, Judge. Not a threat, but judges need to know. Some of them get annoyed when lawyers do that, but a good lawyer always does that. Says, Judge, just so you know, I need these specific findings in writing so that I can appeal it.
Following today's hearing, I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand Judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with Judge's ruling at that time. And I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. And at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime,
Could you imagine that? It's like they have a 5-hour hearing, and instead of being able to watch and listen, we get a transcript to read. It's like, yeah, it's barely making it public, but I give him credit. It's like if we figure out after the fact we overstepped, we can fix it. We can solve it by making the transcripts public.
meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.
All right. And that's it. Everybody hit the like button if you haven't already. I don't think I said that. Would appreciate it if you hit that like button and if you subscribed. Michelle said, Thank you for pointing out the distinction between the gag order and the closing of documents / hearings. I think he's irritated with the defense attempting to cherry pick what the public gets to see, essentially trying to have it both ways. The defense definitely should not get to choose, this is public, this is not. But the defense, just like the state, may have different arguments depending on what the motion is, the hearing is, the piece of evidence is. They can have differing arguments. I think this should be public, this should not be public. And I do think sometimes that would sound like it's in the defense's favor because it's like, let's say the state was going to throw out something like Kohberger was implicated in some other break-in. That's totally false. If you throw that out there, everybody's going to think he's guilty because if he did it multiple times, he's guilty. Judge, you should not make this public. Can be very different than the police trampled on Brian Kohberger's rights. The police lied in an affidavit and the public should be able to see that and hear that. That's different, in my opinion, different arguments. It happens a lot in cases. And Michelle L. had another comment that I wanted to comment on was just because you disagree with the judge doesn't mean the judge is corrupt. 100% correct. That would make every judge I've ever practiced in front of corrupt, right? Because I disagree with half of them on half the issues, right? Every lawyer comes in. There's two lawyers. One agrees with how the judge rules. One disagrees with it a lot of times. Doesn't mean they're corrupt. That's the point of the law. That's the point of people having differing opinions and making arguments. That is the point of the court system. That's why this case is here. Okay, so that's all we got. I appreciate you guys joining me. If you guys want me to break down what happens in the hearing, at least the public parts, let me know in the comments. Let me know by liking the video. And we'll have more for you this week. I love hanging out with you guys live. We will continue to do this on this case as long as you guys are interested in it. So just continue to let me know. So that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.